My name is Meredith Havard, and I'm an attorney who specializes in probate and estate administration. Now, you're likely thinking, what is probate and why do I care? Now, put simply, probate is the court process of determining who owns assets at your death and how those assets are to be distributed. Probate also includes the request from the court to appoint a personal representative who is a fiduciary who is tasked with managing your estate, to validate a will or the lack thereof, determine your heirs, and determine how those assets are distributed. Now, the word probate often evokes fear, as most people have a misunderstanding of what probate is. Often clients will come to me and their first concern is, do I need to probate this estate? And the answer depends on how assets are owned. Probate is determined by asset ownership. If an asset is owned individually in the name of the decedent, that asset is a probate asset. If you do not have an asset that has a named beneficiary or any rights of survivorship, again, that is a probate asset. If you have a bank account and there is no one else listed, that asset will need to pass through probate. Now you might ask, why do you need to go through probate? And the answer is simply to provide certainty as to heirs and provide instructions as to how to distribute an asset. Again, it can come up because of property or assets owned solely by a deceased individual, if there's no identified beneficiary, or even if there are disputes among heirs, or any question about the validity of a will, or there are no estate planning documents whatsoever. Whether an asset is part of that probate estate depends on how it is owned or titled, and whether or not it passes directly to another by law, such as through survivorship or beneficiary designation. If you have an asset that's owned jointly or with a beneficiary designation, that will pass directly to the surviving joint owner or named beneficiaries. If not, any assets that are individually owned and there is no beneficiary designated, that asset will be distributed pursuant to the terms of your will if you have one, or through intestate laws. If you die with no estate planning whatsoever, you are considered intestate. That means that your assets are distributed in certain prescribed ways to your next of kin as defined by statute. This may be completely in opposition to what your wishes are or how you want to distribute your assets. And if there is any question about the validity of a will you have, the court also needs to determine its validity. There needs to be a determination of heirs and a review of estate planning documents to ensure that the intent of the deceased is followed. Now, there are a variety of ways to actually probate an estate, and this can depend on whether or not you die intestate or if you do have estate planning documents. There are three primary ways in Massachusetts to probate a will. One is voluntary administration, another is informal probate, and another is formal probate. Again, this is all dependent on the type of assets you have, whether there is real estate, and if you are anticipating the will being contested. Now, the process put simply is you file a petition, whether that's an informal or formal probate. You send out notice to the interested parties, which also includes publishing in a newspaper so that creditors are aware of your passing, having the court appoint a personal representative who could be named in the will or through the process of intestacy, creating an inventory of assets, securing those assets, paying necessary debts and taxes, and distributing those assets. There are a great deal of documents to file that all carefully conform to statutory authority, and they can be very difficult to navigate. The entire probate process is often overwhelming, and you should consult counsel on this, as again, there are a wide variety of documents and they all need to be followed. Often clients have absolutely no idea of where to start when their loved one died, especially if they died without a will. There is already an emotional strain, and your loved ones now have to deal with the whole probate process, which they likely know nothing about, and are also digging through your information to find out what assets you have, do I need probate, and how do I possibly move this forward. And sometimes, if there is no will, or if an asset is still left in individual ownership, people are stuck in the probate process trying to access that asset when maybe they need to use it to pay for things such as funeral expenses or property upkeep. Probate should be something to be avoided because it can cause undue expense and stress when your family members are already stressed. Probate also makes parts of your private life public access, as court records are accessible. And again, the notification process also includes publication of the estate, which opens up your estate to further creditors' claims and announces that there is a probate. It could also have heirs who are coming out from the woodwork who could possibly contest the will. One of the key reasons to avoid probate is that it is time-consuming. Probate can take months, even years if it is contested. This can result in great expense, as again, if there is litigation, the whole probate process can be protracted, again, for years. And even a simple probate can take months, as courts often have a high volume of cases to review, and there can be a number of any unanticipated issues, such as finding additional accounts, missing heirs, and the list goes on. Having to engage legal counsel, review the paperwork, and make decisions where you have little to no guidance can be more than overwhelming and exhausting. Even retitling assets and ensuring they are properly moved to estate accounts takes time. Now, avoiding probate can be as simple as not needing the court to determine ownership of assets. Usually, probate comes up because of a lack of an estate plan, or again, because of how assets are titled. One simple way to avoid probate is to create an estate plan. An estate plan always comes with a will, where you name a personal representative, and you also can determine how you want your assets to be distributed. That could be to a specific person, or it could be to a trust. You can also have joint accounts that pass to a survivor or pass outright to designated beneficiaries. When you are planning for your estate, you need to look at everything. That includes your assets, that includes your paperwork, that also includes with thinking about who you want to have your assets and who you want to have as a personal representative to administer your estate. If you use a trust, you do need to ensure that assets are titled in this trust. While there are obviously estate and tax implications to any estate plan, there are simple ways that you can avoid probate, such as naming some joint account holders or beneficiaries on your accounts. Again, if you have a more complex estate, that can also be planned for as well, as there are a number of considerations. A trust may not be for everyone, but simple estate planning is. Again, there are a variety of ways to achieve your objectives and ensure your loved one received your assets in a streamlined way. A simple will can also look to waive the requirement of a bond, nominate guardians for your minor children, and explicitly spell out who should inherit and allow the authority to sell real estate. There are a number of different estate plans, and you should always consult a lawyer, but thinking thoughtfully and working with the right professionals to create a plan can avoid probate. If you pass without a will or have assets that do not have a listed beneficiary, you run the risks of assets going to people that you did not intend to receive. You may have wanted a certain person to receive a benefit, but did not take the appropriate actions to do so. You may have wanted someone to become guardian of your children, but you never specified on the paperwork as to how to do that. Estate planning is also important in the event of your own incapacity. You can execute a healthcare proxy and durable power of attorney in order to specify who can make medical or financial decisions for you if you do in fact become incapacitated. Estate planning and thinking about probate is important if you are married or if you are single. You need to think about your legacy and how to try to ease the burden on your family. It is very easy to put off estate planning as thinking that you won't need it for quite some time. And again, there are intricacies of probate, and there is a lot to think about that can quite frankly be overwhelming. But your family members will be put in the place of being overwhelmed if you do not engage in estate planning and think thoughtfully about what you want to happen at the end of your life. While you are living, you can discuss plans and issues with your loved ones. You can discuss how you want property to pass, and then you can make an informed decision. rather than having your loved ones who are now stuck without having any guidance or knowing what to do. There will still be challenges when you pass, and there is always the possibility of probate. But you can work to have a guideline in place that will make the process easier. Probate can essentially be thought of as an uninvited guest. You did not wish for probate to come to the table, but it did. And if you have to, it's not insurmountable. It is doable. There are laws in place, and there are plenty of attorneys who can help you walk through this. However, if you can avoid it, you should. There still might be a number of unanticipated issues, such as a will contest or other litigation challenging a testator's intent. But again, you can provide guidance by setting forth your intent with the appropriate estate planning documents. You can also look to try to provide asset protection to your loved ones and work to assist in your lifetime about the information that your loved ones need to know. Paying careful attention to your assets and how they will pass is important and can help to alleviate stress, aggravation, and a long probate process. One of the first things that I ask my clients when they come in is to show me a list of their assets so that I can see what they have and is anything going to have to pass through probate, as that will ultimately determine how the estate administration is going to work. However, it is important to remember that the whole probate process and administration, while daunting, is not insurmountable. It is important to remember that during your life, you can work to limit the time, expense, and aggravation of those you love by thinking intentionally about the end of your life. Thank you.